Places have changed, faces have aged. Memories are starting to fade, one day at a time. Remember, I'm here with you. You're trying so hard just to keep up. Every day's a chance to restart. I'll still be here, trying to pull you through. Every word that's forgotten, every note left unsung. Trust in me, just hold my hand and take me with you. Bring me into a world no one else can walk through. Hold my hand, 'cause I'm still with you. Love teaches hope, that love teaches joy, enable the ones who are frozen in time. Imagine our hearts choosing to shine on a journey that's yours and mine. Yours and mine. Hold my hand and take me with you. Bring me into a world no one else can walk through. Hold my hand. Hold my hand. 'Cause I'm still with you.
Hello! Welcome to the Enabling Festival 2022. My name is Daniel,
And I'm Danny.
and we are your festival hosts this year. The festival aims to explore, challenge, shape perceptions, understanding of dementia and caregiving through technology and the creative arts.
This year, we will focus on the sense of touch, with the theme Touch is Memory.
We have curated many exciting programs for you this year, so please visit us at this website below to see what we have to offer.
So please enjoy the upcoming programs.
Good day, everyone. Welcome to the Enabling Festival 2022. Today, we are happy to have Seow Ling, Associate Director from Eden Law, here with us to share about the Mental Capacity Act. How to make decisions for loved ones when they lack the ample mental capacity for decision making. The team at Eden Law has been supporting our festival since the very first Enabling Festival in 2018. We're very glad to have them back this year. So, Seow Ling, would you be able to share with us about the work that you do at Eden Law?
Yeah. Hello everyone. So my name is Seow Ling and I'm a practicing lawyer. I've been in practice since 2013. So I've been practicing for 9 years now. I'm actually practicing in Eden Law Corporation, which is a law firm that was started to serve the underprivileged communities. The work that we do mainly involves private client disputes. So, for example, divorce proceedings, fights over children, and family disputes over inheritance. Personally, I'm also a professional deputy and donee, and I'm also an accredited mediator.
Wow, that's really impressive, right? So now, could you share with us a little bit more about why the Mental Capacity Act is that important?
Sure. Basically, the Mental Capacity Act, or MCA for short, defines what it means for a person to be unable to make a decision who can make decisions on the person's behalf and how such a person can be appointed. The regulations and principles that govern the making of these decisions are also included in the MCA. These are all very practical issues that caregivers may face and can create more stress for them. And sometimes it may even create disputes amongst family members if it's not handled properly and sensitively. Just to share with you an example that I have, I had a case where all along the caregiver of an elderly lady with dementia was one daughter out of 4 children. The other 3 children, they will actually visit the mother regularly and, everyone kind of got along well, no obvious disputes previously. However, when the caregiver daughter wanted to use the mother's money to pay for her expenses, the siblings started arguing over who is the most suitable person to manage the finances, who should have control over the account and things like that. And they ended up fighting in court over it. So as part of the court proceedings, we actually have a mediation session. Everyone sat down and they shared their concerns about the sister applying for this application, right? They actually had misunderstandings about the caregiver daughter's intended legal authority over the mother's money. So if they had a better understanding of the situation, or if the mother had planned in advance on who she wants to entrust her money to, these disputes could have been avoided.
Okay. So as a caregiver, while we prioritize the needs for our loved ones, it is also important that we look into these aspects to prevent further caregiver stress, right?
Definitely.
So how does it affect our loved ones then?
So other than preventing unnecessary disputes like the one that I shared just now, it's also very important to ensure that decisions can be promptly made, because this can affect our loved ones directly, right? So for example, I had a case where an elderly's HDB flat was selected for SIRS, the en bloc, a few years back. So that was when she still had the mental capacity to decide for herself, and she even chose a replacement flat. But as you know, flats take quite some time to build, right? So when the replacement flat was finally ready, she was already diagnosed with dementia and she could not sign the legal documents. So her children had to rush the legal proceedings because the elderly's neighbors were all moving out and the children were concerned about the mother's safety staying in the old empty HDB block by herself. Yes.
So you talk about making decisions for a person who lacks mental capacity. What kind of decisions does this include? Right? It cannot just be financial alone, right?
Yeah. So there are basically 2 categories, the personal welfare and property and affairs. In general, personal welfare concerns day-to-day care, medical treatment, whether to continue or not to discontinue medical treatment. Property and affairs, as the name suggests, concerns assets and liabilities. So the important thing about having something done in advance is that if there is no planning in advance, when there is something to be handled, or right, for example, where you need to maybe claim an insurance or withdraw money from the bank account, to the third-party organizations, they would not allow some other person there other than the account holder, right, to withdraw money. So it is very important for the caregivers to be legally appointed, right? Otherwise, they would not be able to make decisions promptly or utilize the assets quickly. Yes.
So how about spouses and grown-up children then? If they are able to establish a certain relationship, why wouldn't this be automatically considered authorized or legal?
Yeah, so that is a question that a lot of my clients ask me as well. But unfortunately, even family members must be legally appointed because the third-party organization, for example, the bank, right, wouldn't know whether this person coming to take the money is really going to use it for that specific purpose, right, for the person's welfare. So definitely, even for a family member, right, if they want to handle a person's assets, that person, the caregiver, must actually be a donee appointed under a lasting power of attorney, or apply to court to be appointed deputy so that they are legally authorized. Right? How about yourself? Have you done an LPA, the lasting power of attorney?
I haven't, and I want to go about doing it, and that's why I have a question for you as well. I often hear that I'm still very young, right? And I still have that level of mental capacity. Do I really need an LPA?
Yeah, that's actually a very common response when I encourage people to do LPA.
Right.
But I always tell them we never know when things may happen, right? So I'm sure you have also read in the news reports of young people, getting heart attack, stroke. So we cannot take our current health status for granted. And for myself, because I've seen so many cases, even things happening to young persons, I'm quite paranoid about it. So I actually managed to convince my whole family to do the LPA. And even my siblings and cousins who are younger than me, they have already done the LPA. Yes. And on the same issue, right, of whether, if I'm young, I don't actually need an LPA, I think the important thing to remember is that the LPA can only be signed if you still have the mental capacity. So do it when you're alert, when you're healthy. Don't wait till the last minute when we don't know whether we can witness you sign this document or not. Right? With an LPA, the person who is doing the LPA is called the donor. Okay? With the LPA, the donor can choose the person that they trust. Right? Choose the person that the donor thinks is most capable to decide. Right, so for example, for yourself, you are young, but if you lose mental capacity, would you want to have just any family member handle it for you? Or is there someone that you know is more capable or more suitable as a person to decide for you? So other than saying that, maybe when I'm older, I need someone to decide for me, now is you have a choice. Right? So if you do an LPA, you have a choice. If you lose mental capacity in future, be it temporal, permanent, or even fluctuating mental capacity, the person that you have chosen as the donee under your lasting power of attorney can immediately use the document to make decisions for you. Right? Of course, the person that you choose must also be at least 21 years old and must still have mental capacity. So don't wait till the last minute.
So can I choose my child who is residing with me to take charge of my affairs, and maybe another one to take care of properties and other affairs?
Yes. So when you mention child, I assume above 21. So when you appoint a donee, that person must be above 21. Donor must also be above 21. Yes, if you have two children and you think that one is more suitable to handle personal welfare and the other is more suitable to handle property and affairs, you can actually appoint the both of them to act separately in different categories, right? But if let's say you decide to appoint both to decide everything together, then you also have to choose whether they are to act jointly or jointly and severally. The difference is that to the third party organisation receiving the decision, when you appoint two donees to act jointly, it means that both their agreement must be there before the third party organisation can say that, okay, this decision is valid. Right? But if you appoint them to act jointly and severally, it means that if, say, one person is not available, maybe overseas or something like that, the remaining person can still make a decision. So individual decisions can be considered valid as well. Yeah. So it really depends on your situation. So if, let's say, one of your children is working overseas, right, then you might want to choose jointly and severally, because if you choose jointly and something happens while your child is still overseas, the child who is in Singapore may have difficulties helping you decide.
So what if I have three then? Right? Can I get them to do it jointly?
Yeah. Yes, if you have three children and you want all three to act at the same time, right, then you have to use Form 2. Okay, so LPA basically there's Form 1 and Form 2. For LPA Form 1, you only have a choice of two donees and one replacement donee. So if you have three children and you don't mind, say, appointing two as the main donees and then one as the replacement, that's fine. But I do have clients who say that, it's a bit sensitive if you kind of prioritize two children over the others, right? So for LPA Form 1, unfortunately, that's the restriction, right? And the powers granted are also generic. The donor can only impose restrictions on transactions on residential property without court approval and the power to make gifts. So these are the only two choices under Form 1. If you want to appoint 3 children to act together, jointly or jointly and severally, you have to actually use Form 2. Okay, so outside of the scope of Form 1, the donor must engage a lawyer to customize the powers, to draft out the powers in Form 2. Okay, so in your case, short answer is yes, if you want to appoint 3 children to act together, you can, but you need to use Form 2 instead of Form 1.
So if Form 2 can be customized, does this mean that I can include really specific instructions to how I want to be taken care of, especially how my money is going to be invested or divested?
Yes, yes. So Form 2 basically there are blanks for you to fill in. Your lawyer will have to draft it for you. So definitely you can choose what kind of powers you want. It can be very specific. But of course, you know, when you have specific instructions, sometimes it may not be practical or it may not be workable. So your lawyer should advise you on whether what you want is something that should be drafted in.
The LPA sounds really, really useful. Since the participants of our festivals are mainly caregivers of persons living with dementia, can you share with us how can a person living with dementia make an LPA?
Sure. Whether a person who has been diagnosed with dementia can still make an LPA would really depend on how serious the condition is. As you know, the decline can take quite some time. So I have witnessed LPAs for persons with dementia before. However, I would always request for a doctor's memo to confirm that the person still has mental capacity, because I'm not in a position to assess as a lawyer, right? So other than lawyers, there are also psychiatrists and doctors who are accredited by the Office of the Public Guardian, who can actually be certificate issuers. Certificate issuers are basically people who witness the donor sign the lasting power of attorney. Yeah. So in short, if the person who has been diagnosed with dementia wants to make an LPA, he or she must have a medical memo to see a lawyer. I mean, usually the lawyer would require that, or the person can go to a doctor or psychiatrist to sign the document, right? For LPA Form 1, just to give you a brief introduction as to how to make the LPA, right? Basically, first the form has to be filled up. The donees must all sign in front of a witness as well. Then the donor has to go to a certificate issuer to actually sign the LPA, right? Then after that, send it in for registration at the Office of the Public Guardian.
Yeah, so I read some news that the lasting power of attorney, it's going to go online.
Yes.
So can we just do it online then?
Yeah, okay, so the Office of Public Guardian is actually rolling out this platform called the Office of Public Guardian Online, or OPGO. So in future, the LPA can be created using SingPass. So the donor just has to use the SingPass, create the form, get the donees to sign digitally. Then the donor visits a certificate issuer to sign digitally as well. But the launch date has not been announced yet, right? So if you are still alert and you are still healthy, please just do the LPA as soon as you can, even though it's the hard copy. Just do it. Don't wait until the online one comes out, because we don't know when it's going to be launched. Yeah. So if there are caregivers whose family members have just been diagnosed with dementia, then take action quickly. Obtain a memo from a doctor or sign the LPA with a doctor. Don't wait. Yeah.
So for persons who have been diagnosed with dementia and with the doctor's certificate that they now lack mental capacity, what can we do then? Yeah.
Okay, so if an LPA has not been signed yet and a person loses mental capacity, basically the assets cannot be touched by the family members, even though they may be the spouse or the children, like I mentioned just now, right? So for caregivers who want to have the legal authority to decide, they have to apply to the family justice courts to be appointed as deputy. The process, like what I described earlier, right, for the LPA is quite simple. Fill out the form, get it signed and submit it. For deputy, it's much more complicated. Number one, we need a medical report from the doctor to let the court know what is the assessment of the person's medical condition and description of the extent of the mental incapacity. Then the intended deputy also has to prepare something what we call supporting affidavit, which includes, amongst many other things, the intended deputy's personal information. So that's like employment status, income, whether that person has any liabilities. All this must be disclosed so that the court can decide whether this person is a suitable person to be appointed as deputy, right? Then the deputy also has to come up with a list of the person's assets to let the court know, okay, there are these assets, what are the powers we need to deal with these particular assets.
Yeah. It sounds really complicated.
Yeah.
Can the powers then be very generic, like LPA?
No. So unlike the LPA, the orders in a deputy application are meant to be specific so that it can safeguard the person who has no mental capacity. For example, if the person, if let's say the intended deputy declares that there's a HDB flat, right? And in the application, the deputy says, oh, okay, I need powers to rent out this flat because currently there's nobody staying in there and I need the income. Okay, the court may give the order to say that, okay, you have the power to rent. But say years down the road, the deputy decides that, oh, it's not sustainable to rent out anymore because maybe the maintenance is quite high, the property is getting old, or the market is good, I want to sell. If the order doesn't contain the power to sell the property, the deputy cannot do so. The deputy must apply to court and explain the situation and ask for the order to be varied to include the new orders.
Wow, that sounds really, really troublesome.
Yeah, indeed, it is quite troublesome, especially compared to the LPA. So that's why we always recommend that people do the lasting power of attorney if they still have the mental capacity to sign one. But I think that it is actually necessary for deputy applications to be stricter because the court would not know whether the relationship between the intended deputy and the person who has lost mental capacity, what was their relationship like? Is the intended deputy really a person who is reliable, right? So the court has to safeguard the person who has lost mental capacity. In order to do that, the more direct way, right, is to ensure that the intended deputy doesn't have too wide powers. They only get what they need. Yeah. Another way that the court uses to safeguard the person's assets is to actually have the relevant persons consent to the application, right? Basically, these relevant persons, right, if they do not consent to the application, the court will say that they have to be served or sent a copy of all the documents filed in court so that they know what's going on.
So in this case, how would you define relevant persons?
Okay, so it is defined under the law that persons who are relevant are people who have an involvement in the patient's lives or who are likely to have an interest in the application.
Wow, that's really quite a wide range of people who are considered relevant.
Yes, so the default categories are basically parents, spouse, children, and siblings. So for these default categories, definitely you must either get their consent or you provide proof that they are no longer around, or you have to send a copy of the documents to them. In some cases, other than these people, you also have other relevant persons like close friends or beneficiaries under the person's will. Because if the person has written in the will that I'm going to give to this close friend, my HDB, for example, if the deputy application says, I want to sell this HDB, it directly affects the beneficiary's interests, right? Even though the will has not kicked in yet. So definitely the beneficiary under the will be considered a relevant person as well.
So if I do all the deputy applications, it takes a lot more time from what I'm hearing.
Definitely.
Definitely more than the lasting power of attorney.
Yes.
Is that so?
Yes. As you can hear from the number of documents, it's quite obvious that the preparation time will be way more. So just to give you an idea, when a person comes to me to do an LPA, a lasting power of attorney, if the person comes along with the donees to sign, I can draft the form, talk to them. It can be completed within 30 minutes to an hour, right? Unless they have some complicated issues to consult me on. Otherwise, just the LPA alone is not difficult to understand. It can be completed quite fast, right? Compared to a deputy application where there's actually a lot of waiting time. So for example, the first step is to do the mental capacity assessment, and that can itself take 1 to 3 months. And then we need to liaise with the doctor, get the doctor's schedule, when can the doctor sign the documents. We need documents from the intended deputy as well to prove, like what I mentioned, the asset ownership, the intended deputy's personal information. Then also to liaise with the relevant persons, whether we can arrange a time for them to sign, and if not, then what are the issues, whether we have to send a copy of the documents to them and all that. So I would say on average, each case for deputy application takes about maybe 10 hours or more and is spread over 2 to 3 months. And of course, again, if each case, if it's complex, it can take even longer.
Yeah. And what about the cost then?
Okay, the cost of LPA is very low in comparison to the deputy. Essentially, for the LPA, you only need to pay for the certificate issuer's fee, right? So certificate issuer, just to recap, the psychiatrist or a doctor accredited by the Office of the Public Guardian or the lawyer, right? So it depends on the level of service that the donor wants. Whether the donor needs, for example, legal advice, then maybe the donor needs to go to a lawyer. If not, then if the donor can fill in the form himself, submit for registration himself, then they can just go to a doctor, for example, right? So just to give you an idea, for myself, I actually went to a doctor to sign my LPA. I filled out the form myself. I brought my donees along to the clinic, and the doctor signed for me. I paid $80 for the certificate issuance fee, right? Then thereafter, I sent it in for registration. Okay. In the past, registration fee is $75 for Singaporeans, but it has been waived until 31st March 2023. So when I did my LPA, I did not actually have to pay a registration fee. I only paid for the certificate issuance fee. Yeah.
So that's quite affordable compared to maybe perhaps a deputy application.
Yes. So for deputy applications, even if we don't talk about the legal fees, right? Like I mentioned, you need to file a medical report. So a medical report itself usually costs from $500. It can go up even more depending on which hospital or which doctor you go to. Then there's also the court filing fees, and then there's printing, photocopying, preparing the documents, like searches and things like that. In total, the disbursements can cost about $500. So in total, the medical report and the disbursements will cost about $1,000, up to $1,000.
That's like 10 times the cost of an LPA.
Yeah. So that's why some clients, when they tell me, oh, never mind, I don't need an LPA, I say, if you don't do an LPA, when you end up with a deputyship, the cost is at least 10 times. Why not you just, do your LPA now, if you have someone that you can trust. If later on you don't want, you can change like 9 times, you're still saving some money, So that amount that I mentioned just now, right, it does not even include legal costs. So for people who don't know how to prepare the legal documents themselves and they need a lawyer to represent them in court, the legal fees can be a few $1,000s. So that's even more than 10 times, right?
Definitely, I think given a choice, people would do the LPA. But what if it's someone like me who I don't really have someone I can trust?
Right. You can actually consider appointing a professional donee for your LPA. If you don't do an LPA and you lose mental capacity and you don't have any next of kin who want to volunteer as a deputy, then they can also appoint a professional deputy for you. Okay, so the Professional Deputy and Donee scheme is something that was started in 2018, where professionals from certain industries are qualified to register with the Office of the Public Guardian upon completion of training course and passing the exams, right? For myself, I'm also a professional deputy and donee. So I know that in terms of the registration, we have to actually provide documents to show that we have a credit rating of BB and above. We also cannot have any bankruptcy history, and every 2 years we have to re-register. Yeah. So if you don't have someone that you can think of to appoint for your LPA, you can consider a professional donee.
So in this case, how much would I need to pay a professional donee?
Okay, so to appoint a professional donee, there's no fixed fee. You can actually inquire with a few and then see how they charge. But it really depends. I would say generally, it really depends on the scope of work and the needs of the donor. Because you see, maybe a person has one HDB flat. The scope of work is much lesser than a person who has, say, multiple properties, right? So definitely, in terms of the costing, I would say generally the fee starts from, say, $250 per hour or more, depending on the seniority of the professional donee, the experience and things like that as well. But yeah, if you don't have someone that you can appoint for LPA, speak to a professional donee, and maybe they can give you a fee estimate as to whether it suits your purposes. Yeah.
So thank you, Seow Ling, for spending time with us today. We urge everyone who has seen this program to start considering and acting on this particular issue on the lasting power of attorney. We have come across many caregivers to persons living with dementia who is dealing with this situation right now. For those who want to find out more information, you may want to search for Eden Law online. Thank you for tuning in to the Enabling Festival 2022. We have other amazing online programs and workshops at the National Gallery of Singapore. So do log on to the festival website and also locate us on our social media. Take care and see you at the festival. Bye! Hi, my name is Daniel.
And I'm Danny.
And we're the founders of the Enabling Festival 2022. We hope you can support us by pledging $1 to the Enabling Festival via the link below.
That's right. This $1 will enable the festival to further its cause and implement initiatives for collective impact, which has societal benefits for the dementia community and caregivers.
Dementia is a very real issue that could happen to you and me. We sincerely appeal to you to walk this journey with us. Your pledge of $1 is in exchange for a treasured trove of shared knowledge.
Come and participate in the various programs. We hope to see you at the next Enabling Festival in
2023. Take care. Bye.
Hold my hand and take me with you. Bring me into a world no one else can walk through. Hold my hand. 'Cause I'm still with you.
Thank you for watching our program.
We hope you can fill in a simple survey using the QR code provided.
This will help us to improve as well as to fulfill our funding requirements from our various sponsors. Thank you.
If you wish to find out more about the Enabling Festival 2022, please visit our Facebook page, Instagram, TikTok, and website.
To connect with us, please drop us a message on any of our social media platforms.
Take care and stay safe.